Always something. I apologize for the interruption. Early on, there would not have been needed. Can you check now? Reconnected. It looks like it should be. I don't see any reason that it wouldn't be.
Okay.
I'll go on. There are some students here that are, you saw them in the hallways handing out the brochures, and it won't be, it'll be something to do with the YouTube. Oh, did we get it? Okay, now we got it. The students, I do not have everyone, but if you are one of the student participants that are working with Robert, if I could have you raise your hand. I know there are a bunch in the, yes, good turnout, and thank y'all for being here. Thank y'all for helping Robert. I know I've got some of their names: Tamara, Lola, Jay, Jill, Brandy. I should have looked at this first and got the pronunciation. Sanjana. Okay, and Remy. So good to have all of y'all. I'm glad that you were here to correct me on that. Okay, two things that we do differently when we do traveling arguments than when we hold it in our court. We do allow folks to take photos during this period of time when I'm doing the introduction. We normally do not allow any photos during any part of the court proceedings, but you can do that here, especially if you don't use flash. That's, we would appreciate that so that we're not distracted. But the other thing that we're going to allow, and these two attorneys have appeared before us before on the traveling arguments, and so they know, and they get to turn to you all and talk for 3 minutes to put the case in context. In that 3 minutes, they can tell you anything that they want to about the procedural history of the case or the facts of the case, to put it in context for you to better understand the legal arguments that they are about to make to us as a court as to why, on the one side, that the judgment from the trial court should be reversed, or on the other side, why it should be affirmed. To help you follow in that, if you're expecting a result today, you're going to be disappointed. It doesn't happen today. It may be weeks or months after today, because what will happen after today's oral argument, we will go back to the court in Waco. We've got a huge electronic library, of course, there, and we will do our research. We will write an opinion. It will be circulated to the 3 judges. We will see if we can come to an agreement on what the judgment of our court will be, and then it will be published so that you can follow what happens afterwards. In the pamphlet that was handed out that has a picture of the McClellan County Courthouse on the front, it has the summary of the cases in it as well. On the facing page of the first case, there are 2, I guess they're called URLs that I would draw your attention to. The first one is the court's website. You can go to that website, you can log on, and you can sign up for case mail and follow these cases or any other case that is pending in the 10th Court of Appeals. I encourage you to do that. When the opinion comes out, you'll get an email. It will advise you that something has happened on the case, and you can follow up and see what has happened. The other thing you can do, and this is purely a product or byproduct of the COVID shutdown, our remote oral arguments, is that we now live stream our oral arguments on YouTube. The court has a YouTube channel. The URL is given. You can go back on another day in the future and look at the oral arguments. And for example, Robert and his class will be doing that as they study what happens in the judicial proceeding. Some courts are taking those down. We may ultimately be ordered to do that by the Texas Supreme Court when we no longer have the emergency orders. But at least for now, we do not intend to take those posted oral arguments off of our website so that we posted there indefinitely. Be sure you turn off your cell phones so that they don't make noise. We do allow folks to move around during oral arguments. Please do so with in consideration of the court and the people that are arguing the case so that we're not distracted. Got two great cases today. After the two cases, we may have time for Q&A. So if you have a question for us, we can't talk about these specific cases, but we can talk about generally what our procedures are, and you can certainly say. I want to say thank you to the dean of the facility out here, Christopher Marsh. He's in the back. Thank you very much, and his capable staff that got everything set up. And unfortunately, we now have to have security for us. Just it's the nature of the beast, and Brian Carlisle is taking care of that for us. We appreciate that very much. The one, Brandon Frank, is the Dean of the Social Science, and we're glad to have you here today. And with that, I'm going to take announcements in the cases. We've got two sets, a criminal case first and then a civil case. First, and I'd like announcements of the council, who's going to argue the case and whether or not y'all done this before, if there's anything preliminary that we need to address. So the first case on the docket today is Crusette versus State.
Judge Ryan Calvert for the state of Texas. I'll be conducting the argument today, and I don't have any preliminary matters that we need to address.
Thank you.
My name is Lane Thibodeau. I represent Holden Douglas Crusette, the appellant in the case. I have no preliminary matters I need to take up either, Judge.
Okay, council will be with y'all just shortly. And the second case on the docket is the city of Madisonville versus Hernandez.
Bill Helfand for the appellate city of Madisonville. Request 5 minutes for rebuttal, please.
The way we do it is we do the 3 minutes to the audience, 17 minutes of argument, and you get 5 minutes for rebuttal. Regardless, you can always give us time back, but we don't extend the rebuttal as a response. So you're locked in on 5 minutes, no problem.
Thank you.
And yes,
Your Honor, Andrew Parham, representing Ivan Aristides Cruz Hernandez, the plaintiff, and in the second case. I have no preliminary matters.
thank you, counsel. It'll be just about an hour, I would predict, before we get started with y'all. And so, counsel, you may approach, and you've got 3 minutes to address the audience. The mics are pretty good. Make sure it's on. That's a slide switch. There you go. Thank you, counsel.
My name is Lane Thibodeau. I represent Holden Douglas Crusette. Holden is in the courtroom today, he's sitting directly behind me, which is sometimes uncommon in these appellate cases for oral argument. Today, I'm presenting a case to the Court of Appeals regarding a claim of ineffective assistance to trial counsel. The allegation is essentially that the trial lawyer, the trial counsel that represented Holden, she was retained and paid, did not do certain things, specifically investigating pure experts for a traumatic brain injury, organic brain damage that resulted from a May 2015 automobile, or actually a motorcycle accident, which required hospitalization at Ben Cobb Hospital, extensive rehabilitation at Cure and Houston in the medical center very nearby Ben Cobb. And as a result of his hospitalization, rehabilitation, and surgery, he has suffered what we call TBI, or traumatic brain injury, with secondary grand mal seizures. Now, why this is important is because Holden, in January the 31st of 2017, committed the offense of aggravated assault with a deadly weapon. He pointed a gun. He went into a home and pointed a gun at a 23-year-old Texas A&M student. Now, the punishment phase of the case, there's two phases. There's guilt, innocence, and then there's punishment. Holden pled guilty to the offense for which he was charged. At punishment, it is our contention, and you'll hear development of this during the course of the argument, that his trial lawyer failed to do anything with regard to developing how organic brain damage affect the culpability and blameworthiness of Holden in connection with the commission of the crime itself. So you all have this brochure. We have given you basically the law here, and the law is kind of set out there. It's set out in the brochure about what is needed to be proved here today and what we'll be arguing: deficient performance by trial counsel and whether or not harm existed. I have basically 30 seconds left. Let me just say something to you all as part of the paralegal program. I want to thank Blinn College, the 10th Court of Appeals, for coming here and allowing us to do this. I want to communicate to you all in the paralegal program how important it is that you get out and do those kinds of things that we need you to do in the legal profession. I have been very, very lucky over the course of 37 years to have excellent paralegals, one of whom is sitting up at counsel table with me, that I would not be able to do any iota if it wasn't for them. I encourage you to pursue this to the fullest extent possible, and I thank you for being here today. May it please the court. My name is Lane Thibodeau. I'm a lawyer from Bryan, Texas. I represent Holden Crusette, who is in court here today in connection with the appeal that we have filed in this case. In the 17 minutes that I have in front of you, I will be discussing why the trial counsel, the trial lawyer that represented Holden, committed or ineffective assistance of counsel, and why ineffective assistance of counsel, or IAC, exists in connection with the presentation of the punishment evidence on the open plea of guilty to aggravated assault deadly weapon in this case. The brief itself sets out specifically those things that, or the ways that trial counsel in this case, a retained lawyer out of Houston, Texas, committed IAC. One, that she was deficient in her performance in failing to seek out, consult, or retain a forensic psychologist or a neuropsychologist for purposes of determining diminished capacity on account of diagnosed and documented severe traumatic brain injury. Holden suffered brain damage on May the 6th, 2015. The second way that trial counsel in this case committed IAC was not preparing witnesses or preparing witnesses or investigating witnesses in connection with the presentation of the evidence. The third way that she committed deficient performance was her failure to withdraw as counsel of record after the punishment hearing in the case. She essentially waited 2 weeks until a court sua sponte hearing to actually withdraw as counsel of record. That left basically 10 working days for appellate counsel to be able to marshal the evidence that would be necessary in an attempt to show that trial counsel, the lawyer who failed to withdraw in a timely fashion, committed IAC. I will also be arguing why these things, the second prong of the Strickland case, which everyone knows that is our yardstick here, why harm occurred as a result of the deficient performance that I argue that we believe, and I believe the evidence supports, occurred in this case. So let me start first with the central thing, and as far as the deficient performance, and that is the failure of trial counsel in this case to consult, retain, or have a neuropsychologist perform a neuropsych evaluation for what by any measure was a severe traumatic brain injury. The importance for this case, or the application in this case on that prong of the deficient performance, really takes the two separate ways. One, because of the nature of the aggravated assault. At the punishment hearing, the state called two witnesses: the probation officer who performed the pre-sentence investigation report, a woman by the name of Stephanie Smith, and the victim of the crime, a young lady by the name of Madison Peete, who gave very effective victim impact testimony about how this event, how this individual with a gun in his hand, pointing it at her, affected her. That conduct had to be explained or at least contextualized in connection with the traumatic brain injury that Holden Crusett suffered in May of 2015. Seldom do you get the kind of organic brain damage, which is documented in this case, at least at the motion for new trial hearing that we had.
Counsel, it's my understanding from the record that in the time that you had available, the expert that you engaged was not able to conduct an examination of the defendant.
And that is correct, Chief Justice. And that is central to one of my third prong, and I'm happy to discuss that with you now.
Well, I was looking more towards the part 2 in the harm analysis, because the case authority tells us that we have to find that there was specific testimony that would have been beneficial to your client before we can determine that there's harm. And absent the, I think what the state has called personalization of the traumatic brain injury and the related consequences, how do we get there on this record?
First of all, I would point out that unlike many cases, what we have here is a documented, and again, John Fabian, who we were able on with 10 days notice to actually get records for, to be able to communicate with, and to be able to get actually into the courtroom to testify, to provide the missing gaps that were absent in the punishment hearing. But he in fact said, and this answers the question directly, I have to have a neuropsych evaluation, so it would be necessary to know how far or how deficient or how defective the processing, thinking errors, intellectual functioning would be. The problem that we had was because trial counsel delayed, it made it virtually impossible with the 10 working days to be able to get Holden to John Fabian for the purposes of doing the neuropsych evaluation. Now, what I will say is I will argue to the court that you can't have it both ways. And that's kind of what the state said. I mean, at motion for new trial. Well, there's an absence of the neuropsych evaluation. Therefore, the state, the appellant Holden cannot show harm, but the reason that neuropsych evaluation was not able to be performed, and there is evidence in the record by way of my affidavit, the affidavit that was introduced, I think it's Exhibit 9 to motion for new trial, as well as the proffer that was made at the end of the motion for new trial, that it was impossible to secure peer records, the rehabilitation record, then top hospital record, and to have the neuropsych evaluation that was done. So my affidavit, my testimony by way of proffer at the motion for new trial was specifically to show the harm. That given the 10 working days that we had, it was impossible to secure the neuropsych evaluation that John Fabian said was necessary. And I do acknowledge, you said what we have here, and this is the word that he used in his testimony, a profound traumatic brain injury. We have organic brain damage as a result of the threat. So we do know that it's present, it's diagnosed, it's not speculative. The question is quantifying it. And given the delay in my ability to get and marshal that evidence, we weren't able to get.
So you would distinguish your case from those cases in which an expert was not obtained or utilized at trial by the fact that in this case, it is undisputed that there is traumatic brain injury, whereas in the, I hesitate to say run-of-the-mill case, but the normal pattern of case where an expert was not obtained, it is that if there is a traumatic brain injury or if there is PTSD, then you get this consequence. Whereas in this case, your case, it is undisputed that there is traumatic brain injury.
That is correct, Chief Justice, and specifically in the reply brief that was filed, this is precisely what I argued, that what we have here is not some speculative, ambiguous allegation of PTSD or depression or something of that nature. What we have here is a specific diagnosed traumatic brain injury resulting in organic brain damage. And that does differentiate the case because we know it existed, and quantifying it, being able to explain it and contextualize it was impossible because of the delay in the withdrawal. And it gets worse than that. And this delay in withdrawal, the delay in trial counsel's withdrawal is inexplicable and unexcusable. It's deficient performance.
Well, if you had had a full 10, or not full 10 days, if you had the full amount of time before filing your motion for new trial, it sounds like you would have needed a lot of records. Would you have been able to get this report together that you needed?
The answer is, I think we would have been. Now, I have no way of saying for certain that we would be able to have secured in admissible form, Justice, the medical record from Ben Cobb. But the testimony from Fernando Cruzet at the motion for new trial hearing is those records had been secured, that they had actually gone out on their own and retrieved and secured those records, both from Pierre and from Ben Cobb. They were supplied to trial counsel in Houston, never turned over as part of the PSI. So we would have at least had access to those. In fact, some of those records were submitted or given to John Fabian and underlay his opinions that he expressed during his testimony at motion for new trial stage.
And I realize my question is probably more towards the complaint of only 10 days. It may only move the issue to your first point.
Yes, sir.
But I was just curious if there were records would have been available, you could have had them reviewed, you could have had an opinion by your time deadline.
Judge, and I apologize for calling you judge. That's just it's old habits and
Called me that for 15 years.
Judge, I'll answer that question this way. The most important single factor here was the neuropsych evaluation. You know, in fact, you could have had a standalone neuropsych eval by John Fabian, and he accommodated us in connection with his record review and coming all the way over from Austin and testifying. We could have made time. I'm certain we could have made time. And the fact is that the records that we did have that were provided to John Fabian certainly helped for his ability to, at least to a certain extent, quantify, be able to say this was moderate to severe. He was able to review the medical records for purposes of the Glasgow coma score, which provided that there was a moderate to severe organic brain damage as a result of the buildup itself. So, to amplify this whole issue, and it does kind of dovetail into the first deficient performance as contained in my appellant's brief, the Crusets had provided this information, but it was not provided to Stephanie Smith, the probation officer who supplied the PSI. And if you go through the record, as I did again last night, it struck me that one of the questions that the prosecutor at the punishment hearing asked Stephanie Smith was, did you give the defendant the opportunity to provide medical records to support the information about his medical history? So what Ms. Burns, the prosecutor in that case, is at the hearing is asking is of Stephanie Smith, the probation officer who compiled the PSI, is did they give you medical records to support this TBI that has been subject to or has been discussed? And the answer was yes, 1 page of medicines. And then yesterday they gave me some medical records, but nothing current. That's what you said. That's at volume 3, page 36 of the punishment hearing. But it wasn't just the fact that trial counsel had this information, did not turn it over to the probation officer who's compiling the PSI, the person that the trial court was going to look to for information and background about the single most important mitigating factor. Now, this kind of TBI, organic brain injury, affects empathy. This is from John Fabian's testimony, and is well known. In fact, trial counsel who did testify at the hearing, who had an opportunity to be heard, said she recognized early that the traumatic brain injury was a significant issue, the most significant issue in terms of mitigation. But she did nothing in terms of quantifying it. She would or turn the records over or to get them in admissible form.
Well, that was my question. Are we talking, when you're talking about the medical records, you're talking about those that were not turned over to Stephanie Smith? Were those the same ones that were attempted to be offered but kept out on the hearsay exception?
I'm going to answer that question this way. We have no way of knowing because trial counsel did not take the time to attach it as a bill of review or bill of exceptions. I'm sorry. She obviously qualified trial counsel says, well, you know, hearsay exceptions granted. I want to attach as a bill of exception. She did not do that. So we don't know. What I was able to glean, and this is just from the written record, was that there was a partial, there were partial records that were attempted to be tendered, but we have no way of knowing whether the records that were attempted to be introduced at the punishment hearing were in fact the same records that Stephanie Smith had received the day before. This is inexcusable and certainly deficient performance that whatever form these medical records take that demonstrate not only the severity of the traumatic brain injury, but that he had surgery. He had a subdural hematoma.
Let me ask you one thing real quick.
Yes, sir.
These that records you're complaining about that were not provided to the PSI officer. Was there anything that the trial counsel might have decided they didn't want the PSI officer to know? Anything damaging in there that may not benefit your client?
Well, since we don't have them and since they weren't turned over, it's impossible to know. But let me answer attempt to answer that question this way. Because it was a PSI, they could have been selected. If you think about it, I mean, the PSI officer may have said, well, I have incomplete records, or may have had follow-up questions, because if you review you review what you see from Stephanie Smith is not taking responsibility, not accepting, minimizing, it's in the front of the PSI. But again, to answer your question, I mean, because there was no records turned over, yes, it's possible that there may have been some damaging, but the central theme of the punishment hearing of the mitigation of the brain damage was in fact its severity. And that had to be contextualized. It had to be given over to the PSI officer. And again, just attempt to directly answer the question again, we have no way of knowing. But I don't see anything within the informal context of the PSI that if not all of the records, because they could have been a terabyte of information, so telling how much or how voluminous. In similar situations, there have been records that have been pared back. So you have the emergency department records with the Glasgow coma score. You have the surgical record. You have those things that are most critical that document the injury itself.
Separate and apart from the neuropsychologist, gave you a bit more time. Talk about the other preparation problems in the case. I'll give you a little bit of time.
I'm going to summarize them this way. There was no preparation. It was uncontroverted at the motion for new trial. Fernando Cruzet testified. He did not know until he showed up the day of the punishment hearing. And remember, this is a punishment hearing. You got deferred adjudication probation or ag time in prison. Those are the two alternatives. The sole witness that testified for the defendant did not know till they got there that morning that he was going to testify. There was no preparation. There was no support. There was no support that was being offered by other individuals. We introduced at motion for new trial, pictures of Holden while he was at Benton Hospital, specifically to show that that information was available. There was no preparation. It was as shotgun as anything I've ever seen from a trial lawyer. And again, that's personal opinion, but you don't go into that kind of punishment hearing. And remember, the testimony was that she had done less than 10 of these open plea punishment hearings, which she testified at motion for new trial stage, with no preparation. And I'll close by just saying, if you contrast the prosecutor's preparation to the defense preparation shown at the punishment hearing, it becomes very obvious that there was no preparation for that punishment hearing. I appreciate you listening to me, and we'd ask that the case be reversed and remanded for a new punishment hearing.
Thank you, Counsel. Counsel, you have your 3 minutes to address the audience. You may proceed when ready.
Good morning, I'm Brian Talbot. I'm a prosecutor here at the District Attorney's Office in Brazos County. And the appeal in this case for the state. I agree with my friend Lane Thibodeau about the basic facts of this case. And with respect to the appellant in this case, Holden Crusett, did in fact break into a young woman's apartment at nighttime. And when she discovered him in her home, he did point a weapon at her. You heard Mr. Thibodeau talk about how very effective testimony was presented at trial from that young woman about the effect that this offense had on her and continues to have on her in her life moving forward, being afraid to be at home alone and things of that nature. An additional fact, though, that I wanted to point out to you is it is undisputed, as Mr. Thibodeau, as you heard him say, that the defendant in this case, the appellant in this case, suffered a very severe traumatic brain injury. An additional fact about that brain injury, though, is the injury itself was the result of the appellant's criminal conduct. He was injured when he crashed a motorcycle riding 150 miles an hour, running from police who were trying to stop him. And that happened a couple of years before the aggravated assault that we're here on today. And in fact, Mr. Cruz